Hello, Namaste. This is Aparna Bhat and welcome to my YouTube channel Abhijna Legal Maps. Today we are heading towards day 4 challenge. The topic of the lecture is regarding the old FIR provisions and the new FIR provisions. That is section 154 of CrPC versus section 173 of Bharatiya Nagarika Suraksha Samhita. So, what are we going to learn in this video? So, actually we had created a 48 days challenge and we have already completed 25 days challenge with respect to judiciary examinations. So, these challenges are given in a WhatsApp group. It's in my WhatsApp group which is known as Target Judiciary WhatsApp group, which is especially focused for Karnataka judiciary examination students. But the provisions are like they are applicable to all state judiciary examinations irrespective of the states, because most of the acts are common, right. So, when that is the case, today we are dealing with day 4th, the 4th day challenge provision, that is FIR. So far we have already completed 25 days challenge. So, if you are interested, you can also join that WhatsApp group, the description of which I have given in the link of this YouTube channel. Okay. Beginning with the lecture today. So, we have 154 of CrPC which deals with FIR or information in the case of cognizable offences. So, we also know that there is a new law which has been introduced with respect to the criminal procedures or the criminal laws. 3 laws have been enacted and one of such law is Bharatiya Nagarika Suraksha Samhita. The corresponding provision to section 154 of CrPC is section 173 of CrPC, 173 of Bharatiya Nagarika Suraksha Samhita. So, some changes, major changes have been brought. So, we will see first what the section 154 was all about, what did it contain and what changes have been introduced, and in present what is as per BNSS, what is the law. Okay. See, first of all I want to deal with the old CrPC, that is 154. So, according to section 154 there were 3 subsections. The first subsection had 2 provisos and subsection 2 and subsection 3. So, most of all it dealt with how to make an FIR. The mode of FIR was given, and also it also gave such circumstances where when a woman police officer has to record the information, and what should be the circumstance and how should be the special procedure if the offence is alleged against a mentally or a physically disabled person. So, that's a special procedure which has been prescribed here. Then under section 154(2), it said that the copy of the information has to be given free of cost, and as per section 154(3), it says that suppose the procedure fails here, the officer in charge of the police station does not receive any information at this level, then he can proceed, he can post the information to the superintendent of police. Okay. That was a main section which was containing in this section 154. Then after the new act, when the new act was introduced, we can see almost all the provisions are same except one subsection has been introduced. So, now they have 4 subsections, whereas the section 154 had only 3 subsections, but now it had 4 subsections. So, the subsection relating to the preliminary inquiry, it has been introduced as a new concept. Preliminary inquiry was there, but it was some guidelines had been given with respect to preliminary inquiry in Lalita Kumari case and different cases, but there was no a specific provision for preliminary inquiry. But now a separate subsection is created and a new provision has been included regarding preliminary inquiry, and also the concept of zero FIR, the concept of electronic FIR. So, these kind of changes have been introduced. So, let us understand them one by one. So, 154, if we see 154, section 154, it said that 154 not IPC, it is 154 CrPC. Section 154 was all about how an information with respect to the commission of a cognizable offence is given. Okay? The method of giving information in case of cognizable offence has been prescribed. So, the FIR can be given either orally or in writing. So, if given orally, then it is the responsibility of the officer in charge of the police station to reduce into writing, and he has to read it over to the informant and he should take the signature of him. Okay. This was the procedure which was prescribed, while they say that has to be FIR has to be made. And also another important provision was that whatever substance of such information was there, that had to be recorded in a separate diary or separate book maintained by the police station. Okay. This was given in section 154. Same thing has been given, except two changes have been made. So, they have introduced zero FIR, and also they have introduced the concept of electronic FIR. So, two concepts have been introduced in subsection 1 of the provision, of the new provision. See, they say that zero FIR is something where, irrespective of the offence being committed, you need not give the information, you did not give the FIR only in the jurisdictional police station. You can give the information of the commission of the cognizable offence in any police station, irrespective of where the offence has been committed. Later, that police station, after receiving the FIR, it will forward it to jurisdictional police. Okay. So, this is known as zero FIR. So, this concept was earlier there, some directions had been given, but a separate provision was not made with respect to zero FIR. So, that has been introduced. So, irrespective of the area where the offence is committed, okay, this has been introduced. And the another important new concept which has been introduced is FIR also can be given through electronic mode or by electronic communication, which is known as eFIR. Okay. So, earlier it was only orally or in writing. Even if it is given in orally, it had to be given, it has to be reduced into writing, but now through electronic communication also, because sometimes if an offence has been committed against a woman, it would be difficult for her to face that ordeal in the police station. She may suffer embarrassment to give the information, or she may be in a traumatic condition. Different possibilities are there. That is why they have given the provision of, they have introduced the new concept of electronic FIR, where after giving the FIR electronically, signature can be taken within 3 days, because signature of the person who has given the information has to be taken, irrespective of whether it is normal FIR or electronic FIR. But when it is given electronically, it can be taken within 3 days from the date of the giving of the information. Okay. So, these are the two major changes. Rest of the provisions are same. It has to be maintained in a book. The substance of the information has to be maintained in the book. So, these are and all, everything is the same thing. Okay. And the next provision, what does it say? It says that the woman police officer has to record some of the offences. Either it could be woman police officer or woman officer. So, this kind of information recording which has to be made by woman is applicable to some of the offences under certain sections of IPC. So, we can see there are different categories, 326A, 354, 376 and 509. So, this column is pertaining to acid attack, this column is pertaining to outraging the modesty of a woman and stalking, voyeurism, sexual harassment, and everything will come here. 376 and other sections, related sections are rape, gang rape and other aggravated forms of rape, and 509 is pertaining to intentional insult to a woman. So, when these types of offences are committed, the information has to be recorded by a woman police officer, and if it is not available, any woman officer can record such information. The same provisions have been incorporated in new act as well, but only one change we can find, that is the corresponding sections have been changed, because how Bharatiya Nagarika Suraksha Samhita has been introduced, likewise corresponding to IPC we have Bharatiya Nyaya Samhita, right. So, according to that, the same sections have been, some sections have been clubbed with some minor changes, the same kind of sections have been changed. Okay. Otherwise, these are all sections relating to rape, stalking, voyeurism, acid attack and everything. Okay, everything is same, only the section numbers have been changed because IPC has been, BNS has replaced IPC. That is why the corresponding sections also have replaced the older sections. And likewise, another condition is where if the offender is mentally or physically disabled person, then there is a special procedure of recording such information, and the offences are also this similar thing, same thing have been introduced, except in section 154 acid attack was not included, but here all kind of offences including acid attack has been included. So, if the offence against whom this is committed, offence is committed. So, if that person is temporarily or permanently disabled, so that information has to be recorded by a police officer and it has to be videographed. It should be made in the presence of interpreter or special educator, or it shall be recorded by judicial magistrate under section 164. Earlier it was 164 5A, but now as per new Bharatiya Nagarika Suraksha Samhita, it is section 183 6A. Okay. So, statement under 164 has to be recorded. Rest of the provisions are same. And next comes, see in red color whichever I have marked, earlier the copies of the information had to be given forthwith to the informant immediately free of cost. Now, even victims can obtain the free copies. So, always the informant need not be victim. So, that is why they say the free copies have to be given to the informant also and to the victim also. And the new section which has been, new subsection which has been introduced is with respect to preliminary inquiry, it is 173(3). What does it say? So, if the offence is a cognizable offence which is punishable more than 3 years, but less than 7 years, in such cases the police officer or the officer in charge of the police station has to make out that whether this case is a prima facie case or not. So, the very threshold of investigating or registering a particular case or proceeding with the preliminary inquiry is to know whether there is a prima facie case or not. If there is a prima facie case, then they will proceed with the investigation. Okay. So, whatever it is, it has to be conducted, preliminary inquiry has to be conducted within 14 days of receiving such information, and he has to take the permission from the officer who is not below the rank of deputy superintendent of police. So, either deputy SP or higher officers have to give the permission to officer in charge of the police station to conduct preliminary inquiry. So, this is one of the very important concept which has been included here. And one more thing, the last provision which is the same as in the earlier criminal procedure. It says that if a person is not satisfied because the officer in charge of the police station has not received his information, then he can write the substance of the information and he can post it to the superintendent of police, he can post it to the SP. So, if that SP is satisfied, he can himself investigate into the offence or he can appoint some of the subordinate officers, okay, and he can conduct the investigation like how the CrPC says, and even whoever officer has been appointed by him, he is having the same procedure, he is having the same powers as that of the officer in charge of the police station. Till here all the provisions are same, but one more thing has been included here, that is if any of the methods fail, then what will happen? The aggrieved person can make an application to the magistrate. So, this is a new concept provision which has been included in the new act. Okay. So, so far we have completed the comparison of section 154 of CrPC and section 173 of BNSS. So, major changes are there is introduction of 0 FIR, there is introduction of electronic FIR, some timelines have been prescribed, and also a preliminary inquiry has been added, and also the application to the magistrate has been given in 173. So, this was all about our new act FIR. So, the major changes in the FIR provisions which have been introduced by the new act, that is Bharatiya Nagarika Suraksha Samhita. So, if you like this video, do subscribe to our YouTube channel and do not also forget to like, comment, share and subscribe, because this is a new YouTube channel completely dedicated to the judiciary aspirants of most of the South Indian students, where we do not find as many judiciary related channels or judiciary exams related videos. That is why this, to cover that lacuna, we have started a new English YouTube channel to give to deliver such kind of videos which are helpful for judiciary examination aspirants of Andhra Pradesh, Telangana, Tamil Nadu, Kerala, Karnataka students, and also to the rest of the India. Whoever is interested in English lecture, they can listen to this YouTube channel by subscribing and clicking on the bell icon to receive the regular updates. Okay. So, this was all about our 4th day challenge, and tomorrow I will be again coming up with a new concept, and I will be explaining detail in detail. So, thank you for watching. See you in my next video. And we also have Abhijna Law Series app which can be found in Google Play Store, or you can find it in the link given in the description below. So, do download it, and you can find many free mock tests and free study materials available there. So, this is all what I wanted to say in this video. So, thank you, take care, bye bye.